Hello, testing, testing. Hello, testing, testing. Hello, test.
What officer? What officer? ഒന്നും കേൾക്കാനില്ല കേട്ടോ. ഒന്നും കേൾക്കാൻ. ഇപ്പൊ കേൾക്കാം. വളരെ ഫീബിൾ ആണ്, കേൾക്കാം. പക്ഷെ ഇല്ല, അത് പിന്നെ കേൾക്കുന്നുണ്ടായിരുന്നല്ലോ. ഒന്ന് ഇതിവിടെ കേൾക്കാനുണ്ടോ എന്ന് അറിയാൻ വേണ്ടിട്ട് നോക്കിയത്. ഓക്കെ ഓക്കെ.
That order is being uploaded.
So far as the N. Adityan's case is concerned, Learned Senior will submit on that.
Yes.
So that I thought I will deal with the other matters. Otherwise, it will be a simple repetition. I think I would also like to hear Learned Senior on this point. Now, I just wanted to point out one another aspect on this, which is the which I had submitted, the question of causes omissus. Now, if causes interpretation of statutes. Now, suppose, if something were to be omitted, can the court supply?
Yes.
The decisions of the Privy Council, that is the first decision. Kamala-Ranjan Ray. There are two doctrines, causes inclusive and causes omissus. Both, the judgments say it cannot be. Here the
This is 1939.
yes,
ILR
ILR PC,
triple
90, yes, 1939 PC. That is there, the several estates, so far as the Bengal Tenancy Act, where they provided for succession. So this Patni estate was not mentioned in that. So the question was whether the Patni estate can be supplied by the court. It's just a converse of that.
Yes.
So the last page I will read, because it may be that there is a causus omissus. I hope your lordship has got that. Page 231, the last sentence.
231.
231, the last sentence. For our purpose, it may be that here is a causus omissus. But if so, that omission can only be supplied by the statute. The court cannot put into the act words which are not expressed and which cannot reasonably be implied on any recognized principles of construction. That would be a work of legislation, not of construction, and outside the province of the court. So, this is what I have to submit, Now, when the Travancore Devasam Board Recruitment Act says that all, this is my copy. This is all posts, are covered by this.
Yes.
It would not be, we cannot, my humble submission is supply this omission. Now, Padma Sundar Rao, state of Tamil Nadu, this is a constitution bench decision, where it came in the Land Acquisition Act matter. Now, their lordships, have read to the subsidiary rules of interpretation, that is causes omissus, when cannot be supplied by court. May I take your lordship to paragraph 15? Paragraph 15. I shall take your lordship first to paragraph 12 and then the relevant paragraph 15. That is at page 542.
Council Justin.
No,
Yes.
paragraph 12. The rival pleas regarding rewriting of a statute and causes omissus need careful consideration. It is well settled principle of law that the court cannot read anything into a statutory provision which is plain and unambiguous. A statute is an edict of legislature. The language employed in the statute is the determinative factor of legislative intent. The first and the primary rule of construction is that the intention of the legislation must be found in the words used by the legislature itself. The question is not what may be supposed and what has been intended, but what has been said in the statute should be construed, not as the theorems of Euclid. Learned Justice Hand said, but the words must be construed. Then paragraph 15. Two principles of construction, one reading relating to causes omissus and the other reading regard to reading the statute as a whole, appear to be well settled. Under the principle, causes omissus cannot be supplied by the court except in the case of clear necessity and when reason for it is found in the four corners of the statute. But at the same time, causes omissus should not readily be inferred. For that purpose, all parts of the statute section must be construed together, and every clause of the section should be construed with reference to the context of other clauses thereof. And that the construction to be put on a particular provision makes consistent enactment of the whole statute. This would be more so if literal construction of the particular clause leads to manifestly absurd or anomalous results, which could not have been intended by the legislature. An intention to produce an unreasonable result, said Dankerwood's Lord J. Artemius so-and-so is not to be imputed to the statute when there is another constructions available. Now, my lord, suppose Travancore.
What was the question before the Supreme
The
Court?
question, my lord, was here, my lord, was the Land Acquisition Act, my lord, that declaration in section 6 was quashed by the High Court, my lord.
Yes.
And the question was whether the language
You
of 6.
can read para 3 and 4. because
Yes, ma'am.
Some discussions are there.
The controversy involved lies within a very narrow compass. That is whether after quashing a notification under section 6 of the Land Acquisition Act, a fresh period of 1 year is available to the state government to issue another notification under section 6. In the case at hand, such a notification issued under section 6 was questioned before the Madras High Court, which relied on the decision of three-judge bench in Narsimhaya versus State of Karnataka. Your Lordship finds that after section 4.1 notification, as per the amendment, within 1 year, 6.1 declaration should be there.
Declaration should be.
Declaration should be there. And the only saving clauses, there should be an order of court of stay
Yes.
or something of that like.
Yes.
In other causes, whether it could be supplied by the court.
Hmm.
Their Lordship said no. That is the Padma Sundar Rao's case. So, otherwise,
Which is a relevant paragraph?
paragraph 12
Where
and
the
15.
discussion?
Paragraph 12 and 15.
The discussion of facts is at para 7.
Yes, ma'am. Paragraph 8, my lord. Paragraph 7, the factual scenario where facts are discussed. my lord. There, section 6.1 provides that computing the period of 3 years, then it was 3 years, my lord. Now it is 1 year. The period during which any action or proceeding taken in pursuance of the notification under section 4.1 is stayed by an order of court shall be excluded. Under the Tamil Nadu Act, the action or proceeding is held upon account of stay or injunction, which is
Read
contextually.
para 11.
Para 11. It may be pointed out that the stipulation regarding the urgency in terms of section 5A of the Act has no role to play when the period of limitation under section 6 is reckoned. The purpose for providing the period of limitation seems to be the avoidance of inconvenience to a person whose land is sought to be acquired. Compensation gets pegged from the date of notification under section 4.1. Section 11 provides that valuation of the land has to be done on the date of publication of notification under section 4.1. Section 23 deals with matters concerning the determining the compensation, provides that the market value of the land is to be fixed with reference to the date of publication of the notification under section 4.1 of the Act. The prescription of time limit in that background is therefore preemptory nature. In Ramchand versus, it was held that this court has, that though no period was prescribed, action within a reasonable time was warranted. The said case related to a dispute which arose before the prescription of specific periods. After quashing of the declaration, the same became non-est and was effaced. It is fairly conceded by the learned counsel for the respondents that there is no bar on issuing a fresh declaration after following due procedure. It is, however, contended that in case of fresh notifications to be issued, the market value has to be determined on the basis of the fresh notification under Section 4 of the Act, and it may be costly affair for the state. Even if it is so, interest of the person whose land is sought to be acquired cannot be lost sight of for acquisition of the land. If the acquisition sought to be made is done in an illogical, illegal, irregular manner, he cannot be made to suffer on that count. The rival pleas, that is the relevant paragraph. The rival pleas regarding rewriting of a statute and causes omissions need careful consideration. It is well settled principle in law that the court cannot read anything into a statutory provision which is plain and unambiguous. A statute is an edict of legislature. The language employed in a statute is determinative factor of the legislative intent. The first and primary rule of construction is that the intention of the legislation must be found in the words used by the legislature itself. The question is not what may be supposed and has been intended.
Paragraph 16 is the loading.
Paragraph 16, my lord. The plea regarding the applicability of stare decisis principle is clearly unacceptable. The decision in Chinnathambi Gounder was rendered 2269 much prior to the amendment of 1984 Act. If the legislature intended to give a new lease of life in those cases where where the declaration under Section 6 is quashed, there is no reason why it could not have done so by specifically providing for it. The fact that legislature specifically provided for periods covered by orders of stay or injunction clearly shows that no other period was intended to be excluded and that there is no scope for providing any other period of limitation.
Yes.
The actus curiae and eminam gravabit highlighted by the full bench of Madras High Court has no application to the facts of the case.
Yes.
My humble submission is, my lord, similarly, my lord, causes of omissions cannot be readily inferred also where none exists. So that is my submission, my lord. There. No, my lord. So my lord, I am not citing any other decision, my lord. In reply, I will cite. So, my lord, the statute I had read once, my lord. Preamble I had read, it says all it is comprehensive so far as the preamble is concerned, my lord. And the statute comprehensively covers the question of when the word all is used, my lord. All posts are covered. So, my lord, we cannot make an exception. Otherwise, the statute would have clearly made an exception that 1 year Shanti. Suppose, my lord, under the Travancore Devasam Board, somebody were to appoint a driver for, that was pointed out by Leonard Senior, my lord. If somebody were to appoint a driver for a month, can we say that it is excluded under all posts? The 1 month appointment will not come under the Travancore Devasam.
Are you saying that the normal recruitment process has to be conducted insofar as a
yes, as contemplated under the board?
He has to be a person with the required qualification, even if he is a
that has to be prescribed, my lord, by the recruitment board. Now, my lord, the recruitment Travancore Devasam religious.
Is there any provision for a recruitment of a person for a period of 1 year?
No, my lord, all posts.
Yes.
So, which in my submission is that it encompasses all posts,
Yes.
whether it is 1 year, 30 days, 1
Yes.
month, or whatever temporary appointment, everything encompassed within this, my lord. Now, so far as what my learned friend said is that notifications say between 18 and 35. If the under the rules, my lord, the board has to request, Cochin Devasam Board or the Travancore Devasam Board has to request the recruitment board.
See, insofar as this is basically a selection to the post of Melchandi, though
The other is also a selection.
no, so selection to the post of Melchandi. And certain categories of persons will be from because who are already in service of Travancore Devasam Board. They can apply. Certain persons will be from Cochin Devasam Board. And certain persons will be from controlled institutions under Malabar Devasam Board. If it is a recruitment, how a person from Cochin Devasam Board can be appointed as a Melchandi at Shabarimala?
There is no impediment under the rules, my lord. There is no impediment. He can apply.
Hmm.
He can be appointed, provided there is a selection process that is provided under the rules.
Yes.
And then he can
Is
be
there any
appointed.
provision under the recruitment rules for appointing a person from another, because Cochin Devasam Board or a Travancore Devasam Board, vice versa? Angotum shift ചെയ്യാൻ.
Recruitment by transfer, your lordship is asked.
Yes.
No, my lord, there is no.
Nothing is.
Recruitment by transfer is not contemplated in the case of 1 year Shanti. If
And these rules provides for a direct recruitment. These rules provides for a direct recruitment. Both this Cochin Devasam Board and also Travancore Devasam. And all those direct recruits will be getting a tenure till the age of retirement. They can't be asked to go after 1 year.
suppose temporary appointment, my lord, 180
No,
days.
that is an entirely different concept.
It is not provided in the rules.
Yes.
My only humble submission is that court cannot
Ah.
read into the rules which is not there in the
Yes.
rules. That's all.
So your
No,
answer is that there is no provision in the rules for making this type of recruit.
My submission is
So
that all,
because here the candidates, because this can very well be termed as a selection to a particular as male Shanti.
let us take, my lord, the case of
So
another
a
temple.
person from Cochin Devasam Board can apply. A
No, but
person
let us
from,
take-
Malabar Devasam Board can apply, and a person from Travancore Devasam Board can also
No,
apply.
my lord, there is a temple known as Chettikulangara temple.
Yes.
Chettikulangara temple.
Ah.
There, my lord, a backward community member applied. He was selected after written test and he was posted in the Chettikulangara temple. Then there was a clamor that since he belonged to backward community, he cannot enter the sanctum
He
sanctorum.
asked you that specific question when you place you raise some contention with reference to the recruitment rule.
So,
It's
my lord,
not
that
based on
he
any
was
caste or something like
no,
that.
he was appointed under the recruitment rules.
Yes.
Shanti is appointed under the recruitment rules.
That is regular recruitment. A person who is
Yes,
above
regular
18
recruitment.
years,
Regular recruitment.
18 or above, he will get a regular recruitment and he can serve in any of the temples under Cochin. Suppose he is recruited to Cochin Devasam Board, then he can serve as Shanti in the Cochin Devasam Board is having around 403 temples. So in any temple, he can continue, he is liable to be transferred. And he can he can be in service till attaining the age of retirement, unless he is thrown out on some charges.
I leave it as that. I
Proceedings.
leave it.
Yes.
Now, my lord, I am taking your lordship to that I shall, after I, my lord, in reply, I will say, my lord, that this will not apply. The judgment of the Supreme Court, which is a compromise decree, will not bind any one of us.
Yes.
Because it's a compromise between uncontesting parties, my lord. Because this matter, whether a Malayalam Brahmin, was never adjudicated. It was taken as a,
Yes.
that's all.
That's
After my learned senior submits and my friends submit, my lord, in reply, I should say.
Good petition. You are arguing in 14136.
Yes, sir. 14136.
Relieves exhibit P13 to the extent it restricts that condition stipulated, and subsequently it was amended exhibit P16 and P17 are also
Sorry,
under challenge.
the relief, sir.
Relief.
Yes, relief is issue a writ of certiorari, or a writ or order direction to set aside P13 notification to the extent it restricts
Restriction is.
applications only from Malayalam Brahmins.
You have also sought for a declaratory relief.
Yes,
And then by way of amendment, P16 and P17 are also under challenge.
yes, sir.
That
But
is
in-
based on during the pendency of the writ petition, your application stands rejected for that particular reason.
Yes.
Yes.
So the narrow issue we are raising in this writ petition is only on the issue of eligibility criterion
Yes.
for Malayalam Brahmins. Sir.
Yes.
That's the only narrow issue, sir, not the other issues. So I'd like to begin, sir, with all respect and humility. First of all, thanking you for this opportunity, and then to reflect on why we are here, sir, considering this issue. I think we are here because there is
So you are only on that restrictive clause.
on that's only on that issue, sir, Malayalam Brahmin, whether it is constitutionally permitted to restrict eligibility to only Malayalam Brahmins. That's the only issue, sir, in this writ petition.
Yes.
So we are here because the Constitution lays out certain rights, and those rights conflict with this provision that we are challenging. If there was no Constitution, we would not be here, sir.
Yes.
Because there's a clash between some constitutional value and this provision. And so I think our focus should be on what that constitutional value is and whether it is overriding or not. And I would submit, sir, in addition to equality, the core constitutional value at stake here is untouchability. Article 17 not only prohibits but criminalizes untouchability. Yes. It is probably the only, to my knowledge, limited knowledge, it's the only constitution in the world which creates a crime. And this is not an IPC crime, it's a constitutional crime, untouchability. And underneath that crime of untouchability, sir, is a belief that by birth, some human beings are pure and some are less pure. I've referred to that in my written submissions, which I've given to you, sir. I've given the authorities saying that. Basically, the belief that some human beings are born pure and the others are born impure. In fact, the word caste, so Portuguese word, is actually a word that means separating the pure from the impure. So therefore, it was a very precise usage, referring to the belief that human beings are impure. So that is why, sir, the two petitioners that Mr. Rajesh represents and I am also representing belong to non-Brahmin castes, highly experienced, fully qualified, and we have to ask ourselves, why are they being denied the right to apply to be male Shanti of Shabarimala? Why are they being denied? It is not the Constitution. It is not a set of laws or regulations. It is a belief that they are impure by birth. And when you say Brahmin, you are saying a group that is pure by birth. There is no other basis to exclude them from being considered to be male Shanti of Shabarimala, except the belief that they are impure. So the question is, sir, can we uphold such a belief? In which case we are abrogating the Constitution. Whatever the details may be, sir, whatever the details may be of administrative law, which we have been looking at, we cannot abrogate the Constitution's belief that no human being can be considered impure by birth. So the bottom line is, sir, history will look back at this High Court's judgment. We'll all be gone, dead and gone before long. But history will remember whether this court abrogated the Constitution on Article 17 or not, or whether it upheld the principle that no human being can be considered impure and excluded only for that purpose. Whether Brahmin is a class or a caste doesn't matter, sir. This is hair splitting, sir. What the name is, it is the belief, the underlying belief that has to be destroyed, sir. Now, given not only on this issue, but similar issues, that there is a conscious and deliberate attempt by the Constitution to change some of these beliefs so that the country can move forward. We have in Article 25, sir, an extraordinary provision, which is probably not there in many other, if any, constitution. In Article 25(2), as you know well, sir, that enables a state to make law or apply existing, Article 25(2), sir. Forgive me, sir.
Yes.
Article 25(2), sir, says nothing in this article shall affect the operation of any existing law or prevent the state from making any law, I'm moving to B, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of people, of Hindus, sorry. Now, this throwing open is not simply the opportunity to go and stand outside and pray, sir. It is also the throwing open of the opportunity to be a male Shanti, sir.
Yes.
So that the disabilities that were attached to them are removed. We also have, sir, Sir, in the judgment of Sabarimala judgment, sir, Indian Young Lawyers Association,
Yes.
and others versus State of Kerala, the
So your Article 20.
2019.
Argument is that this throwing open Hindu religious institution.
Yes,
Not only permitting entry, but all
all functions, sir.
functions and all.
All functions, sir. So that the underlying belief is what is being attacked, sir, that some human beings are impure and others are pure. That is what the Constitution is attacking, sir. The practice of that has been criminalized, but that's the ideology that we are attacking, sir. So that our essential equal humanity is recognized. And
Yes.
so the Constitution has gone to that extent to give power both in Article 17 and 25 to be. But, sir, the judiciary has evolved, sir. A very, very, very sophisticated mechanism to resolve this conflict between the need to protect constitutional values and the need to have freedom of religion, and to ensure that both are protected in a balanced and harmonious manner. And you're very familiar with that jurisprudence. But I would like to summarize that, sir, in if you look at the judgments, sir, 2019-11 SCC, Indian Young Lawyers Association, the Sabarimala case, judgment of Justice Nariman, sir.
2019 SCC. Page 1.
Sir, you go.
Yes.
Sir, page number 139, para 176, sir. After very succinctly and eloquently summarizing 15 of the leading cases on
Page number 139.
139, sir.
139.
Yes, sir.
Yes, para
Para 176. sir.
176.
So before this para 176, Justice Nariman very eloquently and succinctly summarizes some 15 leading judgments on the issue of how to reconcile constitutional values and rights and the right to religion. And then he says, a conspectus of these judgments leads to the following propositions. So it's a very excellent summary of
Yes.
of how the judiciary is trying to ensure constitutional rights are upheld against
Yes.
contrary religious beliefs. Article 25 recognizes a fundamental right in favor of all persons, which has reference to natural persons, not to religious institutions. This fundamental right equally entitles all such persons to the said fundamental right. Every member of a religious community has a right to practice the religion so long as he does not in any way interfere with the corresponding right of his co-religionists to do the same. The content of the fundamental right is a fleshing out of what is stated in the preamble to the Constitution as liberty of thought, belief, faith, and worship. Thus, all persons are entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. Now I move to 176.6, sir. Just
Yes.
a couple paragraphs down. It is only the essential part of religion, as distinguished from secular activities, that is a subject matter of the fundamental right. Superstitious beliefs which are extraneous, unnecessary accretions to religion, cannot be considered as essential parts of religion. Matters that are essential to religious faith and or belief are to be judged on evidence before a court of law by what the community professing the religion itself has to say as to the essentiality of such belief. One test that has been evolved would be to remove the particular belief stated to be an essential belief from the religion. Would the religion remain the same or would it be altered? Equally, if different groups of a religious community speak with different voices on the essentiality aspect presented before the court is then to decide as to whether such matter is or is not essential. Religious activities may also be mixed up with secular activities, in which case the dominant nature of the activity test is to be applied. The court should take a common sense view and be actuated by considerations of practical necessity.
Yes.
Yes, sir. Then I go, sir, to 176.11. Contrasted with the fundamental right in Article 25(1 is a fundamental right granted by Article 26, which is what is being claimed here. 26B to be particular. This fundamental right is not granted to individuals, but to religious denominations. And it has been held, I'll come to this later, it has been held that Sabarimala is not a denominational temple and they cannot claim rights under 26, the temple. A religious denomination or section thereof is to be determined on the basis of persons having a common faith, a common organization, and designated by a distinct name as a denomination or section thereof. Believers of a particular religion are to be distinguished from denominational worshippers. Thus, Hindu believers of Shaivite and Vaishnavite form of worship are not denominational worshippers, but part of the general Hindu religious form of worship. 4 separate and distinct rights are given by Article 26 to religious denominations or sections thereof, namely, and I go to B, to manage its own affairs in matters of religion, which includes, for example, appointing only Malayalam Brahmins as male Shantis. As in Article 25, it is only essential religious matters which are protected by this article.
Yes.
And then it goes on to the exceptions, sir. And then I go to 176.14. It is clear that even though the entry of persons into a Hindu temple of public character would pertain to management of its own affairs in matters of religion, yet such temple entry, and I would say, sir, that the right to worship and be a male Shanti is equally part of temple entry, sir. Otherwise, you have only a right to enter the outer precincts of a temple, sir.
Yes.
You're confined to the what the Mughals used to call Diwane Aam. You are not allowed inside Diwane Khas, which is a sanctum sanctorum. However, religious practices by the religious denomination or section thereof, which do not have the effect of either a complete ban on temple entry of certain persons or otherwise not discriminatory, may pass muster under Article 26B. Even if they are denominational, sir, even if they are denominational, they should not be discriminatory. Examples of such practices are that only certain qualified persons are allowed to enter the sanctum sanctorum of a temple, or time management of a temple in which all persons are shut out for certain periods. These are not discriminatory practices.
Yes.
These are based on essential qualifications, competence. So what we are saying here, sir, is that we respect the freedom of religion with respect to the essential nature of religion and religious practices. But the Constitution draws a line when you look at the essential nature of human beings based on your beliefs and say this is born as a lesser human and the other is born as a superior human. And on that basis, institute practices under 26B, which are discriminatory, and that is prohibited. Sir, it is on this basis that we look at the decision in Adityan, sir, in the Supreme Court decision in Adityan, which I would like to read a few parts out. It is a 2002 decision, sir. And you may wish to note, sir, that this decision comes a few months after the decision of the Kerala High Court, which approved condition number 1. The decision of the Kerala High Court that approved condition number 1 came before the Adityan Supreme Court judgment.
We are having.
And I would take it, sir, that condition number 1 was by operation of law unconstitutional the moment Adityan judgment was pronounced. And therefore, it could not have been part of any arbitration or mediation proceedings thereafter, sir. Because the moment the Supreme Court pronounced the Adityan judgment and said you cannot have a restriction on Malayalam Brahmins, then that condition of eligibility was struck, if in effect became illegal and unconstitutional. So we can take it that
judgment is on 3/10/2002.
Sorry, sir.
3/10/2002. That judgment.
2002, sir. Yes, sir. And the other judgment is, I will tell you. So the Supreme Court judgment of Adityan is on 3rd October 2002.
Yes.
And the two-judge bench in R.R. Verma versus TDB is 14th August 2002. 14th August 2002. And therefore, as of 3rd October 2002, condition number 1 became illegal.
Yes.
And so it could not have been part of any mediation or any other proceedings. And it was never raised to the Supreme Court, sir. We should take it that the Supreme Court never considered that first clause, sir, because it could not have considered it. It had already struck it down. So it cannot be part of the mediation and the compromise and so on, sir, because of the sequence of events.
Which are the paragraphs in Adityan you want to rely on?
Yes, I will just come to Adityan, sir. I will just come to Adityan, sir. So first I want to say, sir, the issue raised in Adityan is on all fours with the issue raised here. It is said in the first paragraph, the question is whether the appointment of a person who is not a Malayalam Brahmin as Shantikaran or Pujari of the temple in question, that temple, is violative of constitutional and statutory rights of the appellant. That's exactly the question being discussed here. Now the question is, sir, let's look at the reasoning to see on what basis the Devaswam board argues that this judgment is not applicable to Sabarimala temple. It's not a denominational temple. The Adityan judgment applies to all Hindu temples. Yes. It cannot claim protection under 25B. So unless the Devaswam board is a court higher than the Supreme Court, how can they say this does not apply, sir, to the Sabarimala temple? Sir, we should also note, sir, in paragraph 5, Sri R.F. Nariman, learned senior counsel as he then was, contended that the appellant failed to properly plead or establish any usage as claimed. And this being a disputed question of fact cannot be permitted to be agitated in the teeth of the specific finding of the Kerala High Court to the contrary. So in this, till today, sir, the bald claim that this is a traditional custom or usage has not been established through proper pleadings or proper evidence. Nothing more than a bald claim, sir. So it doesn't even deserve to be considered. Now, let us move, sir, to paragraph 17, sir. Paragraph 17. Which explains in what circumstances a temple can legitimately say that only people who belong to a particular group should be the priests.
Yes.
That is not wrong, sir. Under constitutional law, that is not wrong. There are legitimate grounds where somebody can say only people from a particular group can be priests in that temple. What are those grounds? It is explained in paragraph 17, sir. Where a temple has been constructed and consecrated as per agamas, it is considered necessary to perform the daily rituals, pujas, and recitations as required to maintain the sanctity of the idol. And it is not that in respect of any and every temple, any such uniform rigor of rituals can be sought to be enforced. Dehors its origin, the manner of construction or method of consecration. No doubt, only a qualified person, well-versed and properly trained for the purpose alone, can perform pujas in the temple, since he has not only to enter into the sanctum sanctorum, but also touch the idol installed therein. Here it is to ensure that the idol is touched in the proper way, sir. Not to say that a person is impure by birth and therefore he cannot touch the idol. It therefore goes without saying that what is required and expected of one to perform the rituals and conduct pujas is to know the rituals to be performed and mantras as necessary to be recited for the particular deity and the method of worship ordained or fixed therefore. For example, in Shaivite temples, Vaishnavite temples, only a person who learned the necessary rites and mantras conducive to be performed and recited in the respective temples and appropriate to the worship of the particular deity could be engaged as an archaka. If traditionally or conventionally in any temple, all along a Brahmin alone was conducting pujas or performing the job of Shantikaran, it may not be because a person other than the Brahmin is prohibited from doing so, but because he is not a Brahmin. Because the prohibited person is not a Brahmin, but those others were not in a position, and as a matter of fact, were prohibited from learning, reciting, or mastering Vedic literature, rites, or performance of rituals, and wearing sacred thread by getting initiated into the order, and thereby acquiring the right to perform homa and ritualistic forms of worship in public or private temples. Consequently, there is no justification to insist that a Brahmin or a Malayala Brahmin, in this case alone, can perform the rites and rituals in the temple as part of the rights and freedom guaranteed under Article 25 of the Constitution, and further claim that any deviation would be tantamount to violation of any such guarantee under the Constitution. There can be no claim based upon Article 26 so far as the temple under our consideration is concerned. Apart from this principle enunciated above, as long as anyone well-versed and properly trained and qualified to perform the puja in any manner conducive and appropriate to the worship of the particular deity is appointed as Shantikaran, dehors his pedigree based on caste. Dehors his pedigree based on caste. No valid or legally justifiable grievance can be made in a court of law. This is a general proposition that applies to all of India, sir. All of India. And no temple in India is exempt from this, sir. This is the Supreme Court of India, sir. I want to ask whether the Travancore Devaswam Board is bound by Article 141 or not, sir.
Yes.
Let us recall 141. Probably they're not familiar with it, sir. Let me read it for their benefit, sir. It says, the law declared by the Supreme Court shall be binding on all courts within the territory of India. This is the law declared by the Supreme Court.
Yes.
So the question is, sir, why are we even having these proceedings, sir? This matter is res judicata, sir.
Yes. Is that we will consider?
The fact, this question that we have raised, sir, is res judicata because the Supreme Court has decided that dehors caste.
Yes.
You cannot have a caste-based or class-based. You cannot, they've said Brahmin or Malayala Brahmin cannot be a condition to be a priest. It must be properly trained. So this is the law of the land, a general proposition of law, sir, not applicable to a particular temple. of one or the not meant on the facts and circumstances of a particular temple. In fact, if you take the facts and circumstances of a particular temple into account, sir, Sabarimala temple and this Shiva temple are on all fours, sir, because they are both not denominational temples. They both claim that they had ancient rituals and custom and usage. So it's a similar situation, sir. Temples that are not denominational temples, which claim that there is an ancient custom and usage that only Brahmins will worship,
Yes.
are before the Supreme Court, that category of temples. And the Supreme Court has clearly said for all temples, but certainly for this category of temples, such a restriction is unconstitutional. Sir, para 18, sir, I'm not reading extensively. Just if you go down the page, sir, to E, just above, between D and E, sir, para 18.
Yes.
While that be the position, to insist that the person concerned should be a member of a particular caste, born of particular parents of his caste, can neither be said to be an insistence upon an essential religious practice, rite, ritual, observance, or mode of worship. For temples such as that Shiva temple or the similarly situated Sabarimala temple, non-denominational temple,
Yes.
but even for denominational temples, in the case, nor has any proper or sufficient basis for asserting such a claim been made out, nor has any proper or sufficient basis for asserting such a claim been made out either on facts or in law in the case before us also. The decision in Shirur Math case and the subsequent decisions rendered by this court had to deal with the broad principles of law and the scope of the scheme of rights guaranteed under Article 25 and 26 of the Constitution in the peculiar context of the issues raised in invalidation of a provision empowering the commissioner and his subordinates as well as persons authorized by him to enter any religious institution or of place of worship in an unregulated manner by persons who are not connected with spiritual functions as being considered to violate rights under 25 and 26 cannot help the appellant to contend that even persons duly qualified, our clients, sir, me, duly qualified persons can be prohibited on the ground that such person is not a Brahmin by birth or pedigree. This is directly applicable to me, sir, directly applicable to me. None of the earlier decisions rendered before the Sheshamal case related to consideration of any rights based on caste origin, and even Sheshamal related to consideration of any rights based on caste origin, and even Sheshamal case dealt with only the facet of rights claimed on the basis of hereditary succession. And therefore, this is this stands alone, sir. Now coming to the page 125, sir, the conclusion. Any custom or usage, sir, is between just above B, sir, 2 lines above B.
Yes.
Any custom or usage, irrespective of even any proof of their existence in pre-constitutional days, cannot be countenanced as a source of law to claim any rights when it is found to violate human rights, dignity, social equality. It's a very broad statement, sir, by the Supreme Court. Any custom or usage, irrespective of even any proof of their existence in pre-constitutional days,
Yes.
cannot be countenanced as a source of law to claim any rights
Yes.
when it is found to violate human rights, dignity, social equality, and the specific mandate of the Constitution and law made by Parliament. No usage which is found to be pernicious and considered to be in derogation of the law of the land or opposed to public policy or social decency can be accepted or upheld by courts in the country. Sir, with greatest respect and all humility, sir, I think this court is bound by the precedent in Adityan, in this decision, the Supreme Court, in deciding this matter. For the reasons stated supra, para 19, no exception in our view could be taken to the conclusions arrived at by the full bench of the Kerala High Court, and no interference is called for with the same in our hands. In other words, the very wonderful judgment of for the full bench of the Kerala High Court, written by Justice K.T. Thomas, I think is almost incorporated by reference, sir, into the Supreme Court judgment and fully endorsed.
Yes.
So now I would like to turn, sir, to a 2015 judgment, sir, by Justice Ranjan Gogoi in Adi Shaiva Shivacharya, to which you had referred. No, I was just pointing that you had referred to that, my learned colleague
Yes.
here. Sir, there at the end of paragraph 41, that is this. I don't know the paragraph number here. There is a, let me see if the same paragraph number, sir. I think it should be the same.
You are referring para from
No,
SCC.
paragraph there is the difficulty lies in not understanding Sheshamal.
Yes.
Sir, I'm reading a sentence at the end of the paragraph that begins with Sheshamal Supra. I'll just find it, sir. I'll just find it.
No, we are also having SCC.
I'm having another version which I'll just find it in 1 second, sir. Sheshamal Supra, paragraph starting with Sheshamal Supra. Adishai. Sheshamal Supra, no, where is paragraph? Sir, I'll just read that sentence and I'll give you the sentence. It says the constitutional legitimacy must supersede all religious beliefs or practices. Constitutional legitimacy must supersede all religious beliefs or practices. And I'll give you the reference shortly. So now I'd like to turn to Sir, I'd like to turn back to the Shabrimala case judgment, sir. Shabrimala judgment.
Which is the relevant paragraph in 2016 too?
This, I'll just give you the paragraph. Huh? 50.
50.
No, 50, that's constitutional legitimacy. I'll find it. I have another. I have the Supreme Court's version, sir. The Judas version of the Supreme Court.
Sheshamal is 48.
No, Sheshamal Allah. Allah, simply this.
And that paragraph starts with
Sheshamal is 48.
Allah. No, sir. No, sir. No, sir. No, sir. That's not the reference, sir. In the Judas version, it is at the end of para 41. End of para 41. This statement I'm reading, sir. The constitutional legitimacy naturally must supersede all religious beliefs or practices.
SCC, that is paragraph 48.
41, sir?
48.
48. Okay, sir. That's the last sentence in that paragraph, sir.
Yes.
Yes, sir. Thank you, sir. I have this Judas version, sir. That's the downloaded from Supreme Court. Yeah.
Yes.
And yes, sir. And so, sir, I'd like to now turn to back to Shabrimala, sir, and point out that in the Justice Nariman's judgment, sir, on in paragraph 172, page 136. That is in 2018, sir. 2018, as you know, a constitution bench of the Supreme Court has extensively quoted and approved by reference, approvingly referred to Adityan versus Travancore. There was some board Supreme Court judgment in para 172.
Yes.
And it starts, I won't repeat the passage. It says, in Adityan versus Travancore, there was some board, 2002, 8 SCC 106. They're referring to the Supreme Court judgment.
Yes.
This court held that the appointment of a person who is not a Malayala Brahmin as a pujari or priest of a temple in Kerala, who is not a Malayali Brahmin, as held the appointment of as constitutionally, after referring to various authorities, is court held, and then it repeats paragraph 16 and paragraph 17, sir.
Yes.
Finally, this court held on page 138, it says para 18, what I've just read out, sir, it quotes the para 18 of the SEC printer version.
Yes.
Any customer usage cannot be countenanced. I read that to you, sir. That is specially quoted by the Constitution Bench of the Supreme Court. So we can see, sir, that the holding in Adityan has been basically approvingly referred to in by a Constitution Bench and others as well, but by a Constitution Bench relevant to Sabarimala, sir, relevant to Sabarimala. So the upshot of all this, sir, is to say that we are we are bound by the Adityan judgment on this narrow question: can Malayala Brahmin be a legitimate criterion or not? Now, sir, in the alternative, I'd like to make just two arguments, sir. And the alternative argument is quite apart from the Adityan judgment. Is this permissible or not? Is such a discrimination permissible or not? If you say that Adityan does not bind this court, and justifiably, if you take that view, naturally you will only do so justifiably. But if you take that view, you still have to deal with the question whether the Constitution allows discrimination in favor of Malayala Brahmin. And as was indicated, sir, in my written submissions, I've gone into some detail here. In my written submission, sir, in argument 2, I'm pointing out in my written submission that caste is a constitutionally prohibited criterion for selection and appointment to offices, public offices. Sir, my learned friend referred to the example that we discussed before the proceedings began.
Yes.
I was saying, sir, if in the National Judicial Academy, I give an advertisement that I want a driver for 3 weeks, but he should be only a Brahmin. And he cannot apply for the next 10 years. And he cannot leave the campus for those 10 days. He's a Purapada driver. Cannot leave the campus. Purapada Brahmana driver. Will that stand scrutiny, sir?
Yes.
I made a small advertisement saying I want 5-year LLB graduates, not 3-year LLB graduates. That was promptly challenged in the Madhya Pradesh High Court, saying how can you discriminate between 5 and 3 years? And I don't want to go into that. So the duration, tenure of the appointment is different from the issue of discrimination, prohibited discrimination. And that brings me to the point, sir. It is one thing where a group like the Gauda Saraswats or many of the other groups that are mentioned in our cases, sir, if they are having a practice, we'll only appoint. We are not a denominational temple, but we will only appoint. We are a trust body or some other body, we are appointing only Brahmins. It's different from when the state is practicing casteism, sir.
Yes.
The state is saying we will only appoint Brahmins.
Yes.
So this puts it on a entirely different footing, sir. This is not a state in a supervisory or regulatory capacity, sir. What we are seeing here is not a traditional method of recruitment. It's a method of recruitment that the High Court put in place, sir. Because the traditional methods of recruitment had caused a collapse in many of these temples and the administration of these temples and widespread allegations of corruption. In the public interest, rightly, the High Court stepped in and set out, let's have proper procedures for recruitment. Can the High Court, sir, endorse a system of recruitment that is casteist? That allows discrimination on the basis of caste? Can the state ignore Article 17, sir?
Yes.
So state action has to be free of caste discrimination. Article 15, Article 16, and Article 17. So we have to take this issue very seriously, sir, that it is the state that is arguing that we will exclude non-Brahmins. On what theory, sir? On what theory? The second thing, sir, is that there is Brahmin. What is Brahmin, sir? I've given my written submissions. I won't repeat it, sir. I've explained in depth that Brahmin is a social category, sir. It has been described by a catena of scholars as a system of social division. It is not a system unlike what we have seen in Seshamal and other cases where the issue is that there is a religious group that starts a temple or a religious institution, founds it, starts its own system. That denomination practices its own system of worship and rituals.
Yes.
And that denomination is formed by worship and the temples. So the denomination exists around a religious belief and practice. But this is a social system, sir. It is not a religious system. How can you bring in a social division to determine who will be a male Shantis? Where will this end, sir? So therefore, this category called Brahmin, number one, is irrelevant to the question of criteria for undertaking puja and worship. It is irrelevant to that.
Yes.
It is a discriminatory characteristics. It has excluded Brahmins only. No one. There were so many apartheid types of practices in our country which are constitution endings. So this is a socio-political category, number one. Number two, the Devaswam Board itself admits in its counter, sir, that there are many Brahmins who are not entitled to conduct worship. So you now take a person who is not entitled to conduct worship because he's impure, a person who is not entitled to conduct worship, but though he's pure and is a Brahmin, but his particular situation within the Brahmin community is such that he cannot conduct worship.
Yes.
You're permitting the Brahmin to apply and become male Shanti, although he comes from a group within the Brahmin community that is traditionally not allowed to do worship, so he can violate tradition, but the non-Brahmin cannot. That is again, sir, an unjustified discrimination,
Yes.
an unjustified classification, as I said last time, sir. And I've given various decisions, sir, to show that, including Indra Soni, K.S. Jayashree, which have said that caste cannot be taken into account, sir. As I said last time, sir, this is a evil social practice disguised as essential religious, as traditional practice. Sir, great thinker, philosopher Narayana Guru said that evil and good comes looking the same way, sir. They don't come dressed differently, that I'm evil and I'm good. They come in the same costume. What we have here is pure caste prejudice and the ideology underlying untouchability being presented as traditional religious practice. It actually disrespects the religion, sir. The jurisprudence that has been developed is based fundamentally on respecting the religion's essential practices, sir,
Yes.
and trying to rid the community of these kinds of negative practices. Sir, in the Adityan case, in the Kerala judgment, sir, it is recorded that the Devaswam Board made a representation.
Full bench decision.
Sorry, sir?
Full bench.
Kerala High Court
Kerala.
judgment, sir. Yes, sir. There is a statement saying, according to the Devaswam Board, there was no norm ever followed that Shantikaran should be a Brahmin. That's what the Kerala High Court judgment records, that this statement was made to them.
Which is the paragraph?
Sir, I'll give you the paragraph, sir. We'll come back to the paragraph. It may be 7, paragraph 7. Yes, sir. Paragraph 7, sir.
Paragraph.
I'll read it. According to the board, there was no norm ever followed the Shantikaran, Malayalam word for Shanti, should be a Brahmin. On the other hand, candidates, irrespective of their caste, have been appointed as Shanti caste in various temples. So they're narrowing it to saying this is only a problem for Shabarimala temples. But Shabarimala temple is not above the law, sir, and not entitled to practice untouchability. So this is a practice of untouchability, sir. Saying that only a Malayalam Brahmin can be a priest, male Shanti of Shabarimala, is a practice of untouchability, sir. And why should we victimize Shabarimala temple, sir, which is a temple to which people of all creeds, castes, from all over the country go, sir, in great faith and devotions? Why are we forcing it, sir? A group of people are forcing it to be subjugated by the practice of untouchability. We have to liberate that temple, sir, from this untouchability. Sir, now the question, sir, is Malayalam Brahmin a caste? Yes, sir. Sir, sir, then if I may, sir, with your permission, proceed.
Yes, yes.
Yeah, I'm almost done, sir. The question is Malayalam Brahmin a caste, sir? Is Malayalam Brahmin a caste? And there I have provided again details in my written submission, sir. Chapter 6 of the 1884 report by V. Nagamaya on the 1881 Travancore census is titled caste. There are 81 castes listed on page 180 in their quote-unquote order of importance in the Hindu social scale. The first listed caste is Malayalam Brahmin. Of course, caste is a class, sir. As Indra Sawhney has said, caste is a class. We can always say Brahmin is a class. That's not relevant to this discussion, sir. The question is it a caste? An 1884 report by Nagamaya, Travancore census, on the 1881 Travancore census, lists 81 castes, and the first caste listed is Malayalam Brahmin. Chapter 9 of the Travancore State Manual, Volume 2, 1906, by V. Nagamaya, is entitled Caste. Under this chapter, the Travancore State Manual describes castes in Travancore, and states that there are, practically speaking, about 1050 subdivisions of caste in Travancore. The Jati Nirnayam makes mention of only 72 principal castes in Malabar, including 8 classes of Brahmins. It says the term Brahmin is derived from Brahma, the creator, from whose mouth the Brahmins are said to have sprung, and hence their caste name. They are also termed Dvijas and Bhumi Devas, meaning twice born and lords of the earth, respectively. There are 10 divisions of Brahmins of India, in which a group of 5 is known as Pancha Gaudas, and the other group of 5, the Pancha Dravidas. The Pancha Dravidas are number 1, Malayalam Brahmins; number 2, Tamil Brahmins; number 3, Canarese Brahmins; number 4, Telugu Brahmins; number 5, Maharashtra Brahmins. Yes, they are a class, but a class which is a caste, long recognized. The Travancore State Manual enumerates at page 249, 251, 286, 287, 2 types of Malayali Brahmins, Nambudiris and Potis. The Travancore State Manuals enumerates 7 types of Nambudiris. I'm not going into that detail. It also refers to 3 subcastes of Nambudiris. So, sir, it is very, very clear, sir, that that historically there's, Edgar Thurston's Castes and Tribes of India also recognizes Malayalam Brahmin as a caste. So it's very clear, sir, that certainly for well into the 19th century, at least, Malayalam Brahmin is a caste, and no doubt about it. And as far as caste is concerned, we know how the law has treated it. Sir. Lastly, sir, I want to end on this basis, end with where I began in my last submission, because there are two simple, straightforward ways that I understand the issues before this court. So number one is it bound by the Adityan Supreme Court judgment or not? If it is, then it is binding, sir. It is binding. And the judgment is very clear that you cannot have a criterion for Malayalam Brahmin for even to hire a temporary cook, let alone hire a temporary Shanti. You cannot have it. The second issue is, sir, that as I said last time, what the Devaswam board has done is made a number of classifications, which is okay, sir. They've said you should have X experience, X age, X education qualification. That's all fine. But criteria number one says that you must be Malayalam Brahmin amongst inter alia. Now, there they are creating two categories of aspiring people who aspire to be male Shanti, not even apply, but aspire to be male Shanti or interested in applying. One is Brahmin and the other Malayalam Brahmin, and the other is non-Malayalam Brahmin. Now, Article 14 says you cannot discriminate on the basis of caste. Article 15 prohibits discrimination. So 14 gives the right to equality and equal protection of the law. Article 15 says you cannot discriminate on the basis of caste as an expression of Article 14. But the Supreme Court and the High Court's judiciary has said that equality does not mean that you cannot discriminate, but the discrimination must be reasonable. And we have had the test of reasonableness, as you know, sir, better than me, applied through two tests. One is that there must be intelligible differentia. And second, that the intelligible differentia must have a nexus with the object sought to be achieved. Now that has evolved, sir, now into arbitrariness. It gone beyond reasonable classification, saying that arbitrariness is a violation of Article 14, and that there must be reasonableness also. So it's become deeper and broader. So the idea of the necessity for the discrimination to be legal and legitimate has become stronger. Now, when you apply this, sir, first of all, the criteria are not intelligible, sir. As my learned friend also said, it's not very clear who are covered, who are not by the word Malayalam Brahmin, because there are many of these categories and subcategories. Plus, there is no official, so I can't go to the village office and get a certificate saying I'm a Malayalam Brahmin, sir. I can get an OBC certificate, I can get some other certificates, but there is no certification system. There is no official, there should not be, and there isn't an official system. There's not even a census, sir, of this. The government has refused to even do a census on this. Yes. So how do you prove? How do you know a claim is not false? It's that the intelligible differentia are not even practically implementable, sir. Even if you uphold this as the High Court, how will it be implemented, sir? How will it be implemented? How will you prevent fraud? The criteria are not intelligible. Second, sir, what is the nexus with the Travancore Devaswam board? Sir, section 31 of the Act. Sir, yes, sir. 31. And then we look at the preamble to the Act. Sir, section 31 of the Travancore Cochin Hindu Religious Institutions Act says, subject to the provisions of this part and the rules made thereunder, the board shall manage the properties and affairs of the Devaswams both incorporated and unincorporated as heretofore, and arrange for, this is the important part, sir, arrange for the conduct of the daily worship and ceremonies and of the festivals in every temple according to its usage.
And another provision is also there, that is 15A, duties of the board.
Which one, sir?
Section 15A
15A.
is
Yes,
available at page number 12.
yes, sir. Yes, sir. Duties of the board. It shall be the duty of the board to perform the following functions: to see that regular traditional rites and ceremonies according to the practice prevalent in the religious institutions are performed promptly. Sir, this does not refer to caste. Sir. It refers to observing the usages and traditions of the temple. So if there are usages and traditions, we need evidence of that. Sir. We cannot just have a bald claim. And as then senior counsel Rohinton Nariman argued, this has not been pleaded, sir. It has not been pleaded. The evidence has not been put in evidence before the court. It's not been pleaded. So we have to disregard it, sir. That this is not in order to uphold any usage. Plus, as I said, that they have themselves submitted to the Kerala High Court as recorded in his judgment that there is no such requirement, sir. Yeah, that I've said, but simply as a matter of fact, sir, they have not pleaded it. They've denied it, sir. They have denied it. I'm not denying it. According to the Kerala High Court, they have denied that there is such a tradition, sir. So I think we cannot accept that. Sir. So I feel, sir, in conclusion, if you'll permit me to say this, sir, that I feel that the Devaswam Board is in contempt of the Supreme Court, sir. And we have to look into the matter, consult with Mr. Rajesh and my clients to see whether we should move a contempt petition of the Supreme Court, sir, against the Devaswam Board. Yes. For having violated its the judgments of the clear decisions of the Supreme Court on a number and approved and endorsed in 2015-2018, sir. Yes. So I think this is a great a matter of deep and great widespread concern, sir, that we have to end this practice of untouchability, and we have to ensure that properly qualified, properly trained people conduct worship in accordance to genuine, proven traditions and usage. Yes. to satisfy the beliefs of those who believe in Sabrimala and in other temples. Yes. Sir, thank you very much for this opportunity, sir. I'm most grateful to you.
Because last time you could not see, we are not having any prior notice that you are
yes,
arranging that.
No, sir, very,
you could spare only
most very sir. I'm so very grateful.
This part requires detailed arguments. That is the reason why we arranged a special sitting.
Most
yes.
Grateful to you, sir. Most grateful.
Yes.
Thank you.
Which is a repetition. Yes. You're arguing on a 1-4. 144 84 of 2021. And then it's 14136 of 14136 of
14136 by the land senior court. Argued by the and the other
Yes.
one by
2020. Yes.
on the pujas and rituals in Shabarimala and Madikapura Devas are being performed by Melchati belonging to Malayalam Brahmin. As per the customs and practice followed in the temple from time immemorial. That is a stone of consideration for selection of Melchati that is technical to Malayalam Brahmin. It was the practice and custom that followed from time immemorial. Exhibit R3.
See whether just like this Paditaram and Padavu register.
Not that Padivu that note written registers are not there. Stating that
Since so far as this Paditaram is concerned, but
that only the Paditaram only states the Tantri for particular temple who stays Tantri for family that Tantri belongs. That only will be there in the Paditaram.
that alone will be there in
That
Paditaram.
alone will be there in Paditaram.
And what about Padavu?
Not the Tantri. You can say that note on what the Tantram that is being followed in a particular temple. And he is the competent person to say that from this is followed with the
Yes.
Tantri also says that the Tantri is not made a party for any of these recipes. So they say that this is being followed in the temple from Mumbai and the Nelshani post that is selected from Malayalam Brahmins. R3, their options are three. That was the criteria, guidelines prescribed in the law for selection when criteria 1 C.
R2?
R2C.
R2 guidelines.
Malayalam Brahmins hailing from Kerala alone are eligible for appointment.
Yes.
Even before that, the practice in the temple was that the Melchades belong to that particular.
Is there any material to?
The materials may not be written materials are not available. It's a practice being followed in the temple. And now the existing practice in the temple, as per its customs, that being challenged with this petition. So it is for the petitioners to show that it is not the practice being followed in the temple. It is their duty to prove, plead, and establish that it is not the practice in the temple.
Yes.
Not the division bench of this honorable court considered the legalities of the guidelines, and practically after each of the criteria were tested, and in particular the Malayali Brahmin criteria that was considered, and this honorable court upheld in paragraph 8 of R2D judgment.
Paragraph
8 in R2D, in running page 33 of my counter. I read now. It specifically found regarding other conditions, we make it clear that Shantikas belonging to Malayalam Brahmins hailing from Kerala will be eligible for appointment. That's a categorical finding that, my lord, approving criteria 1 that the Malayali Brahmins hailing from Kerala alone are eligible for appointment.
Yes.
So the development after the framing of this guideline that was considered by the division bench of this honorable court in R2G. R2G also the division bench does not found fault with the criteria fixing Malayali Brahmin as the sole eligible category for appointment to this post of.
Whether there is any discussion on that aspect
Milord,
in
R2G,
R1,
Milord,
R2G.
all the criteria are generally discussed. There is
Ah.
no specific discussion with regard to this since it has already been approved in R2D judgment. This paragraph 20.
See, this was a report filed by the ombudsman
Yes.
regarding
Each and
selection.
every criteria, the composition of selection committee,
Ah.
all are considered in detail.
So 3821 of 1990 is the original petition.
That is an original
That was-
petition that is pending even now.
Even now it is pending.
Yes. It's an order.
No, this OP 3821 of
3821 of
19.
90.
See, that was the original petition with some certain
And
general
it's from
directions.
all
were
that
being-
arise on the basis of the report filed by the ombudsman. Yes. It has considered all the criteria.
3821 of 19. Yes.
Which paragraph 20 below. In paragraph 20, it says, now we will now refer to the subsequent developments after the adoption of the existing guidelines way back in the year 2000, which compels us to have a relook in the entire matter. On running page 77, that the entire criteria was relooked. And the division bench does not found any fault in fixing the first criteria. And did not interfere also. Not the third madam, take it before the honorable apex court. And before the apex court also was the entire things considered, and only the dispute was with regard to the composition of the selection committee, which was sent for.
No, that SLP was arising out of some other judge. R2,
As R2D judgment. That also with regard to the
that is against R2,
Yes,
not
yes,
against
yes.
this R2G.
R2D,
It is against R2D.
R2D. Wherein also under the criteria for selection of Melchandis and Shabrimala was the issue. And the matter in dispute was the composition of the
No,
selection committee.
the question, because that is one of the arguments advanced by the council on the other side. See whether this, the clause number 1, whether with a specific reference to clause number 1, there was a challenge in that original petition.
There was no specific challenge on clause number 1. Even then, entire things were considered, and the specific dispute with regard to the composition of the selection committee, which stood for mediation, and the report that was accepted. In it, and in final, we not saying that the entire criteria were accepted, and that is being followed thereafter.
Yes.
But my learned friend submitted that after the enactment of the Kerala, there was some recruitment board act. The Melchandi selection would also go for selection by the Kerala, there was some recruitment board act. Firstly, Lord, I would say that this is a contract appointment for a period of 1 year. This is not a regular selection. Even before the enactment of the Kerala, there was a recruitment board act. The selection of regular Shantikas and the selection of
Any suppose a Melchandi of Cochin, there somebody is selected as a Melchandi of Shabarimala. How his salary will be adjusted?
You know, this is only an honorary. This is not a pay scale for this post.
No, whether he will get.
He will get an honorary.
No, whether
20,000.
no, suppose he is for 1 year he is a Propada Shanti at Shabarimala.
Yes, yes.
Whether he will be paid a salary in Cochin Dasanpur?
He'll be getting salary from the Cochin Development, but
Uh,
if he is getting salary from the Cochin Development, he will not get any salary from Travancore Development.
no, how can he be paid salary from Cochin Development? Because when he
No,
is,
that is not. If he is a Shantikar or employee under the Travancore Development, he will not given any payment. With regard to other
suppose if take a case because there is more than one option. A person going by this notification, if a person is having the required qualification with the experience, he can either be from Cochin Development Board, Travancore Development Board, or from a controlled institution under this one, or even private temples or it is permissible. Suppose a person from Travancore Development Board, a person working in a temple under Travancore Development Board, he is selected as Melshanti. And what is the amount he is getting? You won't get any amount. You won't get anything. But at the same time,
from other Development Boards, they will be paid.
no. See, during the 1 year tenure as Purapada Shanti, he will be paid his normal salary. No. If he is a Shanti from Travancore Development, whether he will draw salary for the very same period?
Yes, he will draw salary for the very same.
What about a male Shanti from Cochin Development?
From Cochin Development Board, he can draw salary from the Cochin Development Board.
No, he is not working there.
It's not under Cochin
Pardon?
Development. Huh? He's not working. in
No,
Cochin
he is not.
Development
He is not discharging any duties in Cochin Development Board.
That's
Ah.
then he will be given only the honorarium at in town to the support as Melchandi for Sabrimala. The
No,
honorarium.
see, we want to know the nature of appointment, and that is the reason we are asking a specific question.
ആ പീരീഡിലെ സർവീസ് എങ്ങനെ റെഗുലൈസ് ചെയ്യുമെന്ന് നോക്കണം.
And how? And
They
no,
are
two aspects are there.
They are not
No.
working in Cochin Development Board or any other temple, they will not
Two-
get the regular salary.
Two aspects are there.
Yes.
Because see, you are taking a person from Cochin Development Board. He is drawing salary. Because in Cochin Development Board, temples are categorized as A, B, and C.
Yes, yes.
And depending upon that categorization, their pay scales is also fixed. So if we are taking a person who is working as a Melchandi in an A-grade temple, he will be drawing a particular pay. Whether he will be permitted to draw it or he will be on leave.
Since he is
No,
working
whether he will be on leave during that
He
period.
can only be on leave, since he is not working there, he is working at Sabrimala, he cannot draw the regular salary from Cochin Development.
Hmm.
So the honorary payable here will be given.
Whether it is appointment by transfer or something like that.
That's a contract appointment for the limited period of money.
പ്രൈവറ്റ് ടെമ്പിൾസിലും പറ്റുമല്ലോ. അപ്പോൾ പ്രൈവറ്റ് ടെമ്പിളിൽ ട്രാൻസ്ഫർ അപ്പോയിന്റ്മെന്റ് പറ്റില്ല.
After their tenure here, they are returning to their parent service.
So what is
It is
the interaction? What is whether he is on leave or
that will not get specific instructions and submit, but that will depend upon the service conditions of their in the other Development Board.
so how you are treating a person who is selected as Melchandi, who is at a time when he is working as a Melchandi of a temple under Travancore Development.
So he will be getting the regular salary in Travancore Development. He will not be paid any additional payment in Travancore Development.
Yes.
That's the procedure.
Hmm.
I will get specific instructions out.
Yes. Because the Advocate Harindranath referred certain provisions under the recruitment rules. Because he says everything should be under the recruitment rules.
The Recruitment Board Act says that the appointment to the post under the board, it is not a regular post under the board. The selection post under as per the Recruitment Board Act to the post of Shantikar are not to the post of post in the as Melchandi. And
Yes.
there is no regular selection also in the post of Melchandi. In the Travancore Devasam Board, the Devasam Recruitment Board conducts selection, regular selection to the post of Shantikar,
Yes.
for which not the age criteria is from 18 years to 36 years for a boy. And here, my lord, for the Melchandi in Sabarimala, the even
Melchandi is only a promotion post.
a promotion it cannot be said that it is a promotion. A
Because-
person, when it is a totally transfer appointment to another temple, as regards other temples,
No, he is in a different scale of pay.
that according to their service in this board, my lord, the pay scale differs. If a person is posted as Melchandi in one temple, after 3 years service, he will be posted in another temple. Then he will sometimes become some Melchandi there. Then here this pay scale will not change.
Yes,
That will
because
afford to-
that is pay protection.
Pay protection. The pay scale is according to his seniority in service in board.
Yes. Yes, you can continue.
In several temples under the board, my lord, in Etimanu temple, Vaikam temple, and Ampalapura, etc., my lord. The appointments to the post of Melchandi are from a particular family or community that cannot be changed.
Yes.
In one temple, Vellayani temple in Thiruvananthapuram, the post of Chandikar, that
that-
belongs to
അത് കാരായ്മ റൈറ്റ് പോലെ
അത് കാരാൻമല്ല, that is regular selection, even that's not the Chandikar post is reserved for the community or Vatika community. That is according to the custom and practice and rituals of that particular temple.
Yes.
As far as the
According to custom, temple appointment, that is their case now. Counterly, suppose we challenge it. Discriminate, but we are working in the matter of going under statute. Complete office. Religious practice.
Yes.
Even before the enactment of the Kerala Development Recruitment Board Act, the procedure for appointment of Chandikas in the regular Chandikas in the Development Board, and that is for the Melchandis in Sabrimala. That's a different. The separate criteria which was prescribed and that was approved by the Honorable Court as well as by the Apex Court was followed in the case of the election for Melchandis in Sabrimala. The revision bench of this Honorable Court held that the appointment of Melchandi in Sabrimala cannot be treated as a public appointment.
2015 case.
That's 2015 5 KC 829.
By Justice
54 KLT
by Justice Thotathil Radha.
by Justice Karan. Paragraph 12.
What is the citation?
That is 2015 4 KLT 614, 2015 5 KC 829. 15 5 KC 829.
829.
Yes. Krishna Namburi. Krishna Namburi was Ramruda also.
Yes.
Let's go to paragraph 12. Towards
Paragraph 12.
considering the peculiar nature of the position adorned by the Melchandi Sabrimala members. This Honorable Court held in paragraph 12 fourth sentence. I will read from now. Next, we proceed to consider plea that the appeals for some of the applicants are erroneously decided by DDB. The process of selection includes weeding out a unfit. That process, to the extent discernible from the terms of settlement regarding the selection committee, is one which provides the manner in which the selection committee has to be constituted and the procedure by which the senior Raja of Pandalam Royal Family will be involved in the process. It also provides the manner in which the senior Raja of Pandalam Royal Family will have access to the extra person being concerned. Beyond that, the internal mechanism of DDB essentially gives the liberty to provide for a mechanism that it chooses to ensure that the unqualified person will not come in. Firstly, and fundamentally, we may visualize the selection to the post of a Melchandi cannot be treated as a selection merely for public employment, and the canvas in which the grounds relating to Article 14, Article 16, etc. of the Constitution of India will not necessarily be carried as a whole. So, my lord, this was rendered considering the peculiar nature of the case post adopted by the Melchandi in Sabrimala. As regards the Adityan state, I may submit that this was a case where a regular selection for Chandikas was conducted by the in the other decision, all the criteria were considered. All criteria were considered in the previous.
Yes, what is your argument in so far as Adityan's case?
Adityan's case, that is a case where a regular selection for Chandikas was conducted by the Ram. One person was belonging to lower caste was appointed as the Chandikar in a particular temple. The petitioner there challenged the selection on the ground that that temple, the Chandikar, would only be only belong to Malayalam, could be appointed only from Malayalam Brahmin community. That case, Honorable, the full bench of this court as well as the Supreme Court held that there was no case for the Travancore Development Board. That either that particular temple, the worship belongs to a particular denomination. And nothing was pleaded or proved in that aspect. So, my lord, that in paragraph 17 of the judgment, is clearly considered. There has been no proper plea or sufficient proof also in this case of any specific custom or usage specially created by the founder of the temple or
Paragraph?
Paragraph 70 towards the last.
Case.
Towards the last, not fifth line on. There has been. There has been no proper plea or sufficient proof. Also, in this case of any specific custom or usage, specially created by the founder of the temple, both those who have the exclusive right to administer the affairs, religious or secular of the temple in question, even on the legality, propriety, and validity of the same, the change in legal was brought about by the Constitution and the law enacted by the Parliament. The temple also does not belonging to any denominational category with any specialized form of worship, peculiar to such denomination or to its tradition. There, my lord, the petitioner, my lord, has to, he was challenging the regular selection, stating that, my lord, if a person from a particular community has to be appointed as Merchandi in that, as Chandikar in that temple. So, my lord, he has to prove, he has to plead and prove that the customs and rituals of that temple permits this particular man, any person belonging to that particular category should be appointed, or that usage of the temple should be without any.
Whether it has to be pleaded, because it's in a case like this, whether it has to be pleaded and proved by the board or by the.
That by the petitioner, that case, the board was making regular selection. In the case of regular selection, board now also accepts a person from all Hindu communities not into for the post of Chandikar. Now also the position of what is of the very same.
Yes.
Is because that position was not pleaded or proved by the petitioner, my lord. This position was taken. Then, my lord, Seshamal's case. That also, my lord, Seshamal's case also, the apex court also. So that, my lord, the denominational categories can have, temples can have worships conducted by persons of particular category. Paragraph 11, my lord. Seshamal case.
Paragraph.
Paragraph 11. Paragraph 11, 17, and 17.
And it starts with.
The agamas have also ruled with regard to the
Yes.
Archega.
That is a para 12 with axis.
Paragraph 11. The agamas have also rules with regard to the Archega. The Shaiva temple, only a devotee of Shiva, and there too one belonging to a particular denomination or group or subgroup is entitled to be the Archega. If he is a Shaiva, he cannot possibly be an Archega in Vaishnavic Agama temple too, whatever caste he may belong, and however learned he may be. Similarly, a Vaishnavic Archega has no place as an Archega in a Shaivite temple. Indeed, there is no part to a Shaivite worshipping in a Vaishnavi temple as a lay worshipper or vice versa. What the Agamas prohibit is appointment as an Archaka in a temple of different denomination. Dr. Kane has quoted the Brahma Purana on the topic Punapradishta at page 904 of the history of Dharma Shastra referred to. The Brahma Purana says that even an image is broken into two or is reduced into particles, is burnt, is removed from its pedestal, is inserted, has ceased to be worshipped, is touched by beasts like donkeys or falls or in impure ground, or is worshipped with mantras or other deities, or is rendered impure by the touch of outcast and the like. In these 10 contingencies, God sees the detail there. The Agamas appear to be more clear with this respect. Sri R. Parthasarathy Bhattacharya, whose authority on Agama literature is unquestioned, has filed his affidavit in so and so, and stated in his affidavit, his special reference to the Vikasana Sutra, to which he belongs, that according to the text of the Vikasana Shastra, Agama, persons who are followers of the four Rishi traditions, that is Ritu, Atri, Mariji, and Kashyapa, and born of Vaikasana parents, are alone competent to do puja in Vaikasana temples of Vaishnavis. They only can test the idols and perform the ceremonies and rituals. None others, however high placed in the society as pontiffs or pandits or acharyas or even other brahmins could test the idol, do puja or even enter the garbhagriha. Not even a person belonging to another agama is competent to do puja in Vikasana temple. That is the general rule with regard to all these sectarian denominational temples. It is therefore manifest that the archaka of such temple, besides being proficient in the rituals appropriate to the worship of the particular deity, must also belong to must also a different denomination is supposed to define the image of by its touch, and should be no pollution or defilement of the image under any circumstances. The archaka undoubtedly occupies an important place in the matter of temple worship. Then we not in pass over to paragraph 16. In this paragraph, not the arguments of the
Paragraph 15.
60. The post of the above submission.
That is 17 and 18.
The force of the above submission made on behalf of the petitioners was not lost on the learned education of Tamil who appeared on behalf of the state. He, however, sidetracked the issue by last paragraph. The learned education argued that the trustee was bound under the provision to administer the affairs of the temple in accordance with the terms of the trust and usage of the institution. If the usage of the institution is that the archakas or pujari of the temple must be of a particular denomination, then the usage would be binding upon him and would be bound to make the appointment under section 55. So that is similar to section 31A, 31 and 15A of the TCHRA Act. That the provision is stated is there 28(1).
Paragraph 17.
Paragraph 16, second paragraph.
See, that is subject to the provisions.
Provisions of Tamil Nadu Temporary Administration and trustee of every religious institution is bound to administer its affairs and to apply its funds and properties in accordance with the terms of the trust, the usage of the institution, and all lawful directions which a competent authority may issue. So that even if the amendment is brought in, the trustee can act only according to the section 28(1), which is similar to section 31 and 15A of our act. So section 31 and 15A of TCHRA Act provides that the board is bound to that is the duties of the board 15A. Shall be the duty of the board to perform the following functions, namely, to see the regular traditional rites and ceremonies according to the practice prevalent in the religious institutions are performed properly. This practice, the appointment of Merchandise from a particular denomination is the practice followed in Shabarimala temple. The board has no other way than to follow this procedure. Then also in section 31, management of Devasam. Subject to the provisions of this part and the rules made thereunder, the board shall manage the properties and affairs of the Devasam, both incorporated and unincorporated as herefore, and arrange for the conduct of the daily worship and ceremonies and of the festivals in every temple according to its usage.
Yes.
Then, my lord, I am coming back to the decision, my lord.
Yes.
Then paragraph 17. We have found no difficulty in agreeing with the learned advocate general that section 28 of the principal act which directs the trustee to administer the affairs of the temple in accordance with the terms of the trust or the usage of the institution would control the appointment of the archaka to be made by him under section 55 of the act. In a Shaivite or Vaishnavite temple, the appointment of the archaka will have to be made from a specified denomination, sect or group in accordance with the directions of the agama governing this temple. Failure to do so would not only be contrary to section 28(1), which requires the trustee to follow the usage of the temple, but would also interfere with the religious practice, the inevitable result of which should be to defile the image. So, Lord, if there is any departure from the usage of the temple, Lord, that it will cause the defilement to the image, that is the idol. Lord, the relief sought in the for the writ petition was a declaration, Lord.
Yes.
To declare that the speculation in express literary notification to the extent that it prescribes that only persons of Malayalam alone are able to apply for the chance of the temples. This was a given part. So, for a relief of declaration, Lord, it has to approach the competent court and give evidence to that. Without that, Lord, in a writ petition, Lord, a declaratory relief cannot be granted. More particularly, Lord, this is a case where, Lord, a system which is followed from time immemorial is challenged in this writ petition, and without proving that, Lord, it is otherwise, Lord, they cannot take a relief of declaration.
Yes. Yes, who is yes. I think that the senior government is also having some throat issues. Whether he is making his submissions today, senior government may not.
No, my lord, no. I'll make my submission later.
Like,
I need only a few minutes because my lord, we are supporting the Travancore Devasam Board.
yes. Mr. Council, then we will do one thing because now it is 4 o'clock. This can be listed on because next Saturday we are having a coffee bossa matter.
അന്നം ബ്രഹ്മ ജ്ഞാനം ബ്രഹ്മ എന്നാണ് ഇതിൽ ആദ്യത്തെ ഭാഗം കുഴപ്പത്തിലോ എല്ലാ ശനിയാഴ്ചയും
Second Saturday, അടുത്ത 17th.
17th.
I'll just finish it in 1.5 hours.
No, because he is not, he's having some issues with
Yes,
his throat
yes.
and he may not be forced to. 17. Because he's also having some throat issues because he
Continue on that day.
so we can finish it on 17th.
Yes.
And by that time the senior government will also be. Correct. I heard detailed arguments of so also the 11th council for the petitioner in WPC number 14136 of 2021. And so also the 11th council for in all other matters you are updated. 11th council for the petitioner for the petitioner in other petitions. We have also heard the arguments of the 11th standing council for Travancore Das. List for further arguments on 17/12/2022 at 10:15 AM. After obtaining necessary orders from the Chief Justice. Yes.
But I'll be obliged if I am also given a copy of the compilation. It seems that my internet here
He is
It's
the
not been served on.
appointed by the division. Again,
written compilation or
written
whatever.
compilation. Yes. You can make a soft copy can be mailed to.
Yes.
Yes.
So that will be better. Now we'll take up that Shabarimala. There is another matter listed at 4 o'clock. You may leave.